Senator James's aide, are you here? Evan, Dylan said nice things. I don't know, but Evan, come on up. Let's do Senate Bill 631, and we will be nice. And again, members of the committee, he is not. How many votes did you get in the last election?
0.
Okay, that means we have to be nicer than, okay, so be nice. Do you have Susan Kavosia, or is that someone else? Susan?
She's the chief of staff, but it's just me speaking
Oh, is it
today.
just you?
Yeah.
Off you go.
All right. Dear Chairman Clippinger, Vice Chair Moon, and members of the committee, for the record, my name is David Purpert. I am Senator James's legislative aide. Senate Bill 631 is an identical cross-file to HB 1019, has no opposition, and has the support of all stakeholders. This bill has a simple goal of better aligning Maryland's obligation under the federal law CAPTA, which stands for the Child Abuse Prevention and Treatment Act, to release information publicly from the Department of Human Services or local Department of Social Services when a child suffers a fatality or a near fatality. It also is the culmination of working closely with Maryland state's attorneys and stakeholders from Georgia who passed an analogous law several years ago. Maryland's public disclosure laws generally, including the one we are revising here, were enacted before and or without knowledge of the federal CAPTA law and its disclosure requirements, the aim of which is to enhance transparency and accountability. Thus, as a matter of practice, currently in Maryland, even if an individual in the affected community, the press, or a nonprofit that is advocating for better child welfare services requested information about a child who died while under the protection of social services, no information is provided. State's attorneys and DHS overwhelmingly block any and all details from release under the broad and highly subjective decision that disclosure could undermine an investigation. There are no time constraints on this decision and no attempt to redact certain sensitive information versus completely blocking all information to the public. Maryland, in other important areas, has recognized that giving some information to the public is critical to keeping government actors accountable and the public informed. For instance, body cameras on law enforcement officers. So too, should this good government policy be applied to when a child that the state has intervened to protect has died or nearly died. Under Senate Bill 631, both DHS and the state's attorneys will have strict but collaborative deadlines to respond in a timely manner to public disclosure requests and to redact, rather than wholesale prevent, information from being released before the conclusion of an investigation or prosecution. It also allows for the balance of information to be provided after an investigation or prosecution is complete. If you guys have any questions, I will answer to the best of my ability. If not, we can get back to you offline.
All right. Delegate Williams, then Conaway.
I just wanted to ask if there was anything else about this really great bill you wanted to add.
You had a whole other minute.
Off the top of my head, not entirely.
What are you doing? Go ahead.
I mean, off the top of my head, I just want to, I guess, reiterate that there was no opposition and that, we got, the state's attorneys, because they're who, were wholesale blocking the release of any information. Mm-hmm. And so you guys probably know Steve Kroll well. Yep. I'm sure he's here a lot. So we worked directly with him, and, this has his seal of approval.
That's great. I'm glad to hear that you worked well with Mr. Kroll and that this has unanimous support. Thank you so much.
Thank you, Mr. Chairman. Thank you for coming in and presenting this bill. You did a wonderful presentation, and I might like to ask you, who wrote this presentation? Did you write this?
So I drafted this, but Senator James revised it too.
You did a wonderful job. Thank you very much.
Thank you.
All right. Any other questions? Seeing none, we thank you very much. And that concludes the testimony for Senate Bill 631. Thank you. Senator West's aide maybe is out there, I believe. I thought. Perhaps. Oh, great. This is about Senator West's bill on grounds for divorce, and I believe that we have made a motion to concur in the Senate amendments, and it's just waited to be acted on the floor. Is that correct?
Yes.
Okay. Do you need to talk to counsel before?
No, I am prepared to go now.
That's fine. So it's in the same position, we would be putting it in the same position as the Senate bill?
Yes.
And everybody loves it?
Yes.
And it's fantastic?
Yes.
And those people think so too? Great.
Yes.
Does anyone have any questions for this panel? Best panel ever. Thank you very much. That concludes the testimony for Senate Bill 36. Wait, Delegate Bartlett has a question.
I'm sorry. I just wanted to know your name.
My name is Joey Connor, and I'm an intern for Chris West right now.
Good job, Joey. Thank you.
Wait, you're an intern? Is this your first bill for that you
Yes,
present?
it is.
It's his first bill, everybody.
Thank you.
Well, now we have a lot more questions. Does anybody have questions? No. All right. No, run away. No, we're not adjourning. Who else do I have? I have administration people. 708. Let's do that. I see other people. I see you out there. We're going to get there. We're waiting for Senator Waldstreicher's aide, who is in the ether yet. Senate Bill 708 from the Health Department. Introduce yourself. Tell us a little more about yourself, but mostly about the bill.
Chair Clippinger. And now I'm terrified, totally terrified. I'm Clifford Mitchell. I'm the director of the Environmental Health Bureau at the Department of Health. Thank you very, very much. The department wants to thank the committee and the chair for consideration of SB 708. In brief, notice the in brief, this bill corrects a historical problem in which the department has been unable to receive directly criminal history record checks from the FBI's Criminal Justice Information System. This bill corrects that problem. The department has worked very closely with the Criminal Justice Information System and the Department of Public Safety and Correctional Services to ensure that we are able to do criminal history record checks for staff who work with children in licensed, regulated youth camps. The department appreciates the support of the committee and also acknowledges the concerns of youth camps about the new process, which the youth camps are concerned could delay results. We acknowledge that concern. We do ask the committee to consider the department's proposal to revise that from 3 days to 5 days, and appreciate the chair and the committee's consideration of that amendment.
Are there questions? All right, well, we got all quiet all of a sudden, so no questions. We thank you very much. You're the only person signed up to testify. What? Oh, sorry, Delegate Valentine, go ahead.
Thank you, Mr. Chair, and thank you, sir, for coming in. I did have one question about the CJIS question. Who will be conducting these checks? Are these employees of, I'm trying to look here, criminal justice record checks? Who will be conducting the checks?
So the way this would work is if I were a youth camp prospective employee, I would get fingerprinted. That result goes to the state, then to the FBI, then the record check would come back to the department.
To the department, that's what I'm trying to get
to
at.
my staff.
Your staff.
And they would then review the results of that. If there's nothing on that, then the camp is able to hire.
Okay.
And if there is something on it, then my staff would adjudicate that to find out whether it's an offense that would prohibit them from serving to interact with children.
So this is a fingerprint process.
That is
They're not
correct.
doing a computer check, like a criminal history check?
It has to be done by fingerprints.
That was my clarification. Thank you. Thank you,
You are
Mr.
welcome.
Chair.
Other questions? Seeing none, that concludes the testimony on Senate Bill 708.
Thank you.
Speak Senator Waldstreicher, and he doth appear. So here, let's see him. Senator Waldstreicher, Bill Kress, Paul Ewell, James Dema. If you're here, I don't know if you have anybody else. Oh, you do. So that's fine. Let's get all four of you up there. And Mr. Vice Chair.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. This will be brief. In almost half the states, there is a law that is provided to avoid the criminalization of land surveyors who occasionally need to step on the next door property in order to complete their job. There were a couple questions about this bill in the Senate, and I will just be clear. The provision in this law only is active when the person is doing the land surveying. Being a land surveyor doesn't give you a trespass anywhere you want ability. And well, I think that's it. That was really the only question on the House. I would ask for a favorable, in the Senate, I would ask for a favorable report.
Thank you, Mr. Chairman, members of the committee. My name is Bill Kress. I'm here today on behalf of the Maryland Society of Surveyors in support of Senate Bill 288. The sponsor hit it right on the head. So this bill simply exempts land surveyors when they're performing professional land surveyor duties. It exempts them from criminal and civil prosecution for trespass. This bill is not unique. 38 other states have similar provisions. And in the state of Maryland, there is a provision that applies for public surveyors. So they cannot be charged with criminal trespass nor be held liable for civil trespass. It's a very straightforward and simple bill, and I will leave it at that. I do have two witnesses who are professional land surveyors.
Afternoon. My name is Paul Yule, and I am the president of the Maryland Society of Surveyors and have been land surveying in Maryland for over 36 years. Land surveying is an honorable profession dating back thousands of years. Today, our work is the foundation of real estate transactions and development in our state. Our base mapping is utilized for infrastructure design of roads, highways, and bridges, and utilities. It is used for commercial and residential development and stormwater management systems. But one of our largest responsibilities is the determination of boundary lines. A big misconception the public has about land surveyors is that we are working in the best interest of our client when we're performing our work. They think we're going to set lines in favor of our client at their expense. This could not be farther from the truth. It is our professional and ethical obligation to reestablish a property line where it was originally intended to be. This is done by thorough research in land records, understanding previous case law, talking to pertinent landowners, and locating all possible boundary evidence in the field that we can. Again, to place the line where it was originally intended to be. We make that boundary determinations on that principle regardless if it benefits our client or the adjoining landowners. It is in our best interest not only for the property we are surveying, but for the property that touches it. And we are allowed to locate all boundary monumentation and evidence to properly determine where that line was intended to be. It is imperative that we be allowed to follow the footsteps of the original surveyors before us. This proposed bill allows us to do the most prudent job possible doing that. It gives us the ability to best serve the public's interest in the work we perform. I respectfully ask this committee to support Senate Bill 288 that allows professional land surveyors to have reasonable access in the performance of their duties. Thank you.
You can pull that over, Jim.
Well, thank you. My name is James Demma. I'm a member of the Maryland Society of Surveyors. I'm also a practicing attorney in the state. And also I teach a course on land surveying and boundaries at the Catonsville campus of the Baltimore Community College. And we talk about trespass laws all the time. And a lot of members of our society, they're somewhat frightened to death of somehow being charged for trespassing either civilly or criminally. But you have to understand, and the witness here, Paul, he gave a very good rendition about the surveyor's obligations in surveying boundaries. We are a member of a time-honored society, but we can't survey a piece of property just look at it as a one entity. We must make sure there's no gaps or gores between adjoining property owners, so the surveyor really can't help himself, so to speak. There are occasions when he must step over this imaginary, invisible boundary line in order to make sure that he has located the proper monumentation in order to satisfy his client's request to have that survey performed. And so it's just no way to avoid simple, every now and trespasses onto properties, or I'm going to say just a little bit of intrusion on somebody's property without causing any damage. And so we, as a society, and on behalf of myself as an individual, I support the passage of this bill. If you have any questions, we're here.
Questions for the panel? Delegate Tomlinson, then Delegate Simmons, then Delegate Crutchfield, and oh boy, here we go, Delegate.
Sorry, I started that. So has there been some incidents recently that kind of inspired this legislation? Or, I mean, any events that, I mean, has there been like some
Yeah,
violence?
that's an excellent question. That's the first question I asked my client when they brought me the legislation. And I brought it in turn to Senator Waldstreicher. So the association, the society, did a polling of the local chapters, and what they found out is that this occasionally happens, and primarily it happens to, unfortunately, to surveyors of color. They're the ones that have been most impacted and affected. Does it happen every week or every month or every year? No, but it does occasionally happen, and this gives them a small modicum of protection.
So, I mean, but what's happening? I mean, is there like a verbal confrontation, physical confrontation, or police called, or?
It's mostly verbal, I would say. There are at times, depending what parts of Maryland you're in, rural areas, it can get a little even more intense. But it's primarily is, I just had a recent situation myself where there was concrete monuments pertinent to a valuable corner that I was establishing, and that we were not allowed to get over to access and get these. And you're not serving that property owners who refuse us the best that we can by having the ability to locate those property corners and set that line where it's supposed to be. So, I mean, yes, it happens, and that's what drives it, but that's the intent of what we're looking for, is just to be able to get the proper evidence we need.
Gotcha. Okay, thanks.
And I've had a couple of occasions also in representing surveyors and happened to deal with the same piece of property and the same property owner, where they went a little bit onto the neighboring property, which they had to recover some monumentation, and peace orders were filed against these surveyors. And we're trying to avoid situations like that.
And real quick, I'll add too, is one thing that you could put your head around is, even if it's that corner and we're not going on their property, we have to set our survey instrument on to locate that corner. You can't set a tripod up, technically, without that leg being over on their property to even locate that corner, for an example.
Thank you. Delegate Simmons, and Crutchfield, and Valentine.
Thank you, Mr. Chair. Just interested in, you spoke about the number of minority surveyors. Can you give me an estimate of what that looks like, what that number looks like?
I couldn't give you a specific number. What I could tell you is my own personal staff that I'm familiar with. I have a set of twin brothers, African Americans, worked for me for 20 years, nicest guys, most polite, follow everything they can with landowners out there. 20 years they worked for me, and I can tell you by far they are hassled the most in the field of getting police called on them and things called, and assuming that they're not.
Can you tell me the number of surveyors in the state of Maryland?
We are somewhere, if you know the specific number.
I don't have the specific number. It's over 800.
Yes.
So two African Americans out of 800, or would you say more?
I'm saying on my staff. I have a staff of 6 field people, 2 of them are.
Okay, so if I have a property and I have a fence around my property, how do you get in it? Do you just get in it, or do you ask permission?
All of my field crews are instructed. I can tell you the majority of all field crews out there, I feel safe speaking for. These typical instruction to your staff is you knock on the doors, you talk to people before you go in and do anything.
Okay, so I say no. Then what?
They do not come on. They leave. They will come back and talk to me. We will try some other resources. Maybe the client can speak with them, things like that.
Okay, thank you.
Delegate Crutchfield.
Thank you, Vice Chair, for bringing this bill. And so good to see you, Mr. Dema.
Very nice seeing you, ma'am.
And I just want to ask you a question, if you don't mind, and that is, do you feel with this bill that you will be able to, all the surveyors will be able to accurately complete a surveying job if you have this kind of bill in place?
One word,
legislation?
one word, absolutely.
Okay, thank you.
Mr. Chair, my questions have been answered. They were Delegate Tomlinson and Delegate Simmons' questions. No.
Thank you, Mr. Chair. Thank you all for coming in to present this bill. I was curious, it's possible that you could survey a property line without being on the other property, because you could place your tripod up in a way where you could target right over top of the mark, and then you could see it from the top of the property down to the end of the property, right?
In certain circumstances like that, yes.
Well, the reason why I asked you that is because I'm dealing with some arc radius geometry, so I just thank you so very much.
That's, he's right. I love this.
Wow. All right. So, any further questions? All right, seeing none. Thank you very much.
Thank you, Mr. Chairman.
Passover.
Thank you all.
I'll be in Delegate Crutchfield's district for Passover tonight, so thank you for hosting
All
me.
right.
Delegate Crutchfield.
Thank you.
Thank you very much.
Senator Carter's aide is here again for Senate Bill 15, so we're going to hear from him. I don't think that there are any witnesses here. Oh wait, Senator Carter is here.
I'm right on time, but no, my chief of staff was ready to go, so you want to continue?
Adrian Muldrow, are they here or did they not make it?
Thank you, Mr. Chair. Actually, Mr. Byrd is probably more prepared than I am because I wasn't anticipating getting here in time to do this. But anyway, I'm hoping this is a very non-controversial bill and you'll deem it a good policy measure and necessary. Last year, after we passed the Juvenile Reform Council Act, the Juvenile Reform Act, which prohibited children under a certain age from being arrested, which I think is good policy. In my district, a 9-year-old shot a 15-year-old, and it resulted in her death. And even though we all knew that there were measures that were possible to be taken under law enforcement contended that there was nothing it could do at all because we had passed this law that said that the child can't be arrested. But we know that a SINS or a SINA petition could be filed in a situation like this. And so what this bill does is it's called the Nikayla Strader Act because the young woman, teenager that was killed, her name is Nikayla Strader. After it occurred, I met with her family a number of times. They felt extremely frustrated but wanted to do something, and I thought this was a reasonable measure. So it just says that if such a thing occurs, the petition for SINS or SINA will have to be filed, an assessment done, and an inquiry into what the child and or family may need, and that those needs would be met. I think it's a good measure, and it wasn't controversial in my committee. I don't believe there was any negative or opposing testimony. In fact, Juvenile Services, I think, agreed with it. I want to say maybe there was a state's attorney that supported it, and definitely you don't have the benefit of this, but the Nikayla Strader family all came a couple of times for this bill, and so I'd ask for a favorable report. I do think it's, it would mean a lot to the family, but I also think it's a good measure, and it would really prevent this false narrative that's arisen that because of a law that was passed by this body, that nothing whatsoever can be done when a child commits an act that is a bad act, that would be a crime if we allowed it to be. So with that, I'm happy to take questions.
Questions? Seeing none, we thank you both very much.
Thank you. Now, the bill did pass with an amendment, Mr. Chair. You should have the amendment, and the amendment actually makes it even better. Okay?
All right, thank you very much.
Thank you.
That concludes the testimony on Senate Bill 15. Appreciate it. There is written opposition, I think, from the Office of the Public Defender, but beyond that, I didn't see any other opposition. You are? Oh, okay. Let's do that. Delegate Williams, sorry.
Oh, okay, there we go. Does the amendment address the concerns from the public defender? I know you said you guys did do some amendments on the Senate side.
I don't know. I apologize. I don't remember. This is Senate Bill 15.
Yeah.
It's been a long time since we heard it. I don't recall the public defender's oral testimony or written, so if you want to let me know what they said.
Yeah, I think they were just saying that it kind of muddles up the intake process and makes it unclear is the gist of what I'm getting from their letter that they submitted, but they don't offer any alternative language. So it's just saying they're urging an unfavorable report.
Well, thank you. Well, what I would say in response to that is it's the Department of Juvenile Services that ought to be concerned about whether something messes up their intake process. And to my recollection, Department of Juvenile Services was submitted testimony in support of the bill, so they didn't think it was a problem. Again, this closes the loophole. It should anyway. And again, I don't think there's anybody that would say that when something like this happens, there shouldn't be some type of intervention, some type of service. I believe it could happen under current law, but this mandates that something happens, and I think that's responsible.
Okay, thank you.
All right, Senator Carter, thank you. I was looking at the letter as well, and I think one of the concerns it sounds like they have is with the details that the Department of Juvenile Services would have to take with their intake officers. I mean, they're almost indicating that they're not able to do so, but that's not what you heard from DJS?
Well, no. So, unfortunately, I am happy to go through the testimony. You should have it in your computers. I'm assuming you have the same as we had in our bill hearing. I'm not sure, but I'm happy to submit it if necessary. I do not recall the opposition, and I recall Department of Juvenile Services being in support, and I think they did submit testimony, at least on the Senate side. But let me say, information, okay. Now, I can't remember what I was going to say, but it's been a long session, yeah.
Absolutely, and it's not finished.
Okay, I know what I was going to say. This is an extremely narrow bill. It does not address everything. It only addressed this certain incident, certain type of situation. So that's why I don't think it's a thing. It's not going to open the floodgates. So no, I don't. Normally, I agree very often with the Office of the Public Defender, but not in this instance. Not to mention, we're not talking about their office. This doesn't even affect their office.
Correct.
This affects the Department of Juvenile Services and the law enforcement.
Correct. We are talking about whatever the DJS wants to put in place to make this happen, really. But I mean, it sounds like they didn't have any issues with it, DJS. So, okay.
Correct. And so this encompasses up to the under 13 years old, which is the minimum age that we said the child would have to be in order to be arrested. And so that's what, now that reminds me, that's what the amendment. So initially I had it at 10 because in my situation the child was only 9, but our amendment lifted it to 13. I think that's a good policy. I do. Not that you all necessarily care what I think, but I do. We passed. We're in the same boat. We're passing a lot of bills. Some we agree with, some we don't. Some we think are good policies, some we don't think so. But I do think this one, I don't see where it's controversial or there. I don't think the public defender in this instance was appropriate to oppose what DJS can do.
Okay. Thank you.
Seeing no other questions, now we're going to let you go. Senate, that concludes the testimony on Senate Bill 15.
Thank you so much.
Senator Watson's aide is here, I believe, for Senate Bill 164. 3 virtual to testify, 6 in person. Again, Adria Muldrow, but they weren't here for the last one, so I'm assuming they're not here for this one. Stacy Bensky, Christopher Dews, Janet Graham, and then virtually Jason Billingsley, Marquise Williams, Gwen Levi. Nobody on virtually. So go ahead. Do you have another?
We had this DeJuan Burton. That's all.
Come on up.
Come on. Yeah.
Who is that young man?
Camden. God. He was the person on the floor, Mr. Chair, who screamed when it was time to change the vote. He was excited about the process.
Okay.
Yeah, that's all.
All right. So we'll hear from Senator Watson's aide, and we'll go from there.
Good afternoon, Chairman, members of the committee. My name is Trey Hayes. I'm here on behalf of Senator Watson to introduce SB 164, Driver's License Suspensions for Child Support Arrearages. Senate Bill 164, as amended, makes an exception to the driver's license suspension statute for child support obligors making less than 250% of the federal poverty level. Simply put, if an individual makes less than $36,450 they will not have their driver's license suspended for inability to pay child support. The bill does not impact other child support enforcement tools such as wage garnishments, tax intercepts, or incarceration for willful noncompliance. A version of this bill passed out of the Senate last year with a unanimous vote, 46-0. This year's version has been amended to allow for ease of agency implementation. It also passed unanimously, 45-0. The Census Bureau reported that almost 50% of Marylanders travel outside of their county for employment. This statistic is more pronounced for lower-income communities of color where there's a scarcity of jobs available by public transit. And a Bell Foundation report found that across Maryland, 50% of non-custodial parents in the state child support program caseload were employed in 2017, and 40% of these people earn minimum wage or less, but owe an average of $10,000 in unpaid arrearages. Additionally, a report cited by the Abell Foundation found that 42% of individuals who have had their license suspended lost jobs as a result of the suspension. 45% of those who lost jobs could not find another job, and 88% of those who were able to find another job reported a decrease in income. In short, individuals that hover near the federal poverty level struggle to meet child support obligations as it is. Losing their license will do nothing to help them meet these obligations, and in fact only hinders them. For these reasons, we urge a favorable committee report with the outlined amendments.
Good afternoon, Chair, members of the committee. My name is Stacy Bensky, and I'm an attorney at Maryland Legal Aid. I represent parents in child support cases. License suspensions for child support arrears disproportionately harm low-income families, and they punish people for being poor. License suspensions are not an effective child support enforcement mechanism for those who are living in poverty. It's an obvious barrier to employment and makes it difficult to be an involved parent. We often hear frustrations from custodial parents when the non-custodial parent's license is suspended, because now that one parent is responsible for all transportation for the family, including driving the child to and from any visits with the other parent. I was before this committee on February 9th and explained already to you guys in detail how the automated license suspension system used by the Child Support Agency operates as if the exceptions in the current law do not exist. And my written testimony explains in detail how the automated system will likely continue to operate as if this new exception does not exist. But Maryland Legal Aid is still we still very much urge a favorable report from the committee. We're still very much in favor of this bill because adding this exception would at least allow for another means of license reinstatement for our clients. So while this bill might not be perfect and it doesn't address the automated system, it definitely takes steps towards mitigating harm to low-income families and breaking the cycle of poverty. However, we have heard of amendments being potentially added to this bill that would mandate non-renewal of licenses for parents who are 250% below the poverty level and owe child support arrears. So this would fly directly in the face of the intention and purpose of the bill. The purpose of the bill is to limit restrictions placed on driver's licenses to allow people better access to jobs so they can actually pay their child support. And lastly, I do just want to say that while we support the bill, we only support the bill as is, not with these potential amendments that would contradict the intention of the bill. Thank you.
Okay. Christopher Dews, Job Opportunities Task Force. So you guys are very much familiar with the bill, and I just want to highlight what some of the differences are. First and foremost, I'll start by saying that we have worked out an agreement with the Department of Human Services. I know that they are probably standing behind me, making faces, but the truth of the matter is there was a lot of back and forth that happened with the bill sponsors, with the department, and now we are pretty much good to go. The package that you are seeing before you that has been sent by Senator Watson's office is the final product that we think would be good to move us in a direction to kind of mitigate the harm that the suspension mechanism can cause. I just want to highlight again that the mission of this bill is not to prevent people from paying child support. It is to ensure that they will have the ability to pay child support and that they will have the access to a license that can get them the employment that can make that happen. I just want to list one last thing before I stop talking here, because I think this sometimes gets confused. There are a variety of tools that the department can use. I just want to go through them really quickly. Garnishing bank accounts, garnishing wages and unemployment, that it can add adverse reports to credit bureaus, report to new employers, intercept lottery winnings, federal and state tax returns. They can revoke your professional and recreational licenses, deny the issuance of a renewal of a passport, incarcerate you for contempt of court for not paying. The only thing we are saying with this piece of legislation is don't touch the licenses for this lower income group, because they need it to secure the employment to get the job to pay the child support. That's all we have to say. I thank you guys, and I'm willing to work with anybody on this committee to get this bill put up for a vote, since this is year number 3. That's all.
Good afternoon. My name is DeWine Burton. I am a member, and I also am an employee of Out for Justice, an organization that supports formerly and currently incarcerated individuals. You want to go sit over there? Yeah, this is Camden Humphrey. He's my son, and oh.
I'll take the picture. You made it there quick, too.
So cute. Thank you. Thank you. Okay, so my name is DeWine Burton, and I work for Out for Justice, an organization that is supporting formerly and currently incarcerated individuals. I'm here on behalf of myself, but also for the constituents and our membership that we serve. I am an unmarried mother, and this is a particular bill that is important to me, not just personally, but also, like I said, in support of our members. Unfortunately, not too long ago, I was laid off, and so I was using government assistance, and so one of the options was, of course, you can get food stamps, but also if you wanted to get cash assistance, you would have to go put, the other parent on child support, and that was something I chose not to do. Because I understand from a personal perspective, but also in the work that I do, that that has collateral consequences that you can't control. I can't control that once I put the state gets involved. And so I chose not to do that for a number of reasons. It also, this particular issue goes to support or criminalize an individual who cannot financially support, the financial keep up with child support payments. And that's not something that I want to do. If I want my child's father, in this case, to be in his life, I need to make sure that I'm doing what I can and he's doing what he can to do that. And some things are out of control. So what I want to highlight is that one of the things that I haven't heard mentioned here is that there are other ways that an individual can provide support. And if a person is not able to work for whatever number of reasons, there is a number of other issues that they can help me with. Like, my son has swim, he has soccer, he's a very active person, as you can see. If he's not able to work, being able to take him to those classes or those lessons are very important to me, so that I can work and I can support myself and also my son. So I just want to say I urge a favorable report for SB 164. Thank you very much.
Are there questions for the panel? Delegate Taylor.
Thank you, Mr. Chair. Thank you so much for your testimony. This is real stuff that really affects people and people's lives. Can I ask, what is the income at the 250% of the poverty level? You mentioned it, and I just...
It is 36,450.
You got it as 36. Now, during the House bill hearing, I mentioned that there's one category, one industry of that really relies on their cars, and that's Lyft and Uber drivers, and their average can go up to around $50,000. So at 250,000, and I'm kind of looking over at DHS, so I know maybe this is why you had this compromise. They would be precluded. It would not be, a lot of them would not be covered under this compromise. And in fact, I was hoping to offer a friendly amendment of 400%, which would go up to 54, which would effectively include them. So are you saying, I know DHS is not on your panel, but are you thinking that if I were to offer a friendly amendment, because I've also talked to both bill sponsors, that at 400%, that it would be a no-go?
I am contractually obligated not to give you a direct answer. I will say that we have, again, worked out a very, very strong agreement with the department. I would say I'll defer to the bill sponsor, but it's just, this was the step. But
so, as Chris said, I think a really important part of this bill is the amount of time all parties involved took to sit down and come to a compromise. I believe 4 or 5 days before a session is at its end would be in bad faith to support that amendment. However, I thoroughly believe that Senator Watson would love to broaden the amount of individuals we can assist, especially in our district. Our District 23, and especially in Baltimore, is where this bill would matter the most. And so basically the short is we would support it. However, I think that it's best to stick with the current language.
there is also always next session.
That's what I was going to say. There's always next year.
I appreciate that. I just wanted to go on record as saying, and I know that this very important piece of our population is left out, and I want to make sure that we circle back to this next year. Thank you.
Phillips. Thank you.
The waiting game.
I'm actually pretty loud. So thank you, and I appreciate you bringing this bill, and I'm very supportive of this bill. There is a technical issue that I am assuming has been addressed, because I know the feds require us to have the tool of suspending a license. And so does this bill address the federal requirement so that we won't lose any money coming from the feds for DHS?
I'll say quickly before Stacey jumps in. We worked it out with the Attorney General's office that should not be an issue. That's the reason why we stuck with the numbers that we stuck with. The federal statute specifically says in appropriate cases that will allow specific language that will allow for the effectiveness of the program. So the numbers that we have chosen, we started at 300. DHS, like I said, compromised us to 250. So that should be in compliance. We shouldn't have to risk that at all. And that's something that we have been working on since 2021 when this bill was first introduced in this fashion. But sorry, Stacey.
Yeah, I echo what Chris said, and I'm from Maryland Legal Aid. So also the AG's office did do a favorable written testimony. So they are in favor at DHS, to our understanding, is on board with this. It should not affect the federal funding. The federal language just requires, and I have the law in front of me right here in the U.S. Code, just that the agency must have procedures under which the state has and uses inappropriate cases the authority to withhold or suspend or restrict the use of driver's licenses, professional licenses, or occupational recreational licenses. So as long as they just have that ability to, which they very much still do.
Thank you.
Good. Thank you.
Delegate Crutchfield.
Thank you, Mr. Chair, and thank you so much for being here and testifying on this bill. Mr. Dews, can you just give us a rundown on how this really, the process will be with MVA for this to actually occur?
Gotcha. So the process, okay, so the way that this would actually go down is if an individual is certified, is qualified under 36, basically if they have an income of less than $36,000 or $37,000, then what the department is now going to do is capture whatever that most recent child support income is. So if you make, let's say, $25,000 at the time of your most recent child support order, what would then happen is if you were at the time, I guess now we went from 2 months to 4 months, but 4 months out of compliance, what would then happen is you would basically a letter would not be sent to the Motor Vehicle Administration. If you make more than the $37,000, let's say you make $43,000, then a letter would be sent. So all it is just kind of it's just taking a look at what the most recent child support order is and determining from that number whether or not you would qualify for a suspension. And it's really that simple.
Thank you. And you said all the details have been worked out with MVA. They're on board and can make this happen.
Yeah, go ahead.
Can I say, it's not really MVA, so it's really DHS, because it's really the Child Support Agency. All of the license suspensions and reinstatements are really all done through the Child Support Agency, and DHS is they are on board, but they are the administration that has to do with all of it. The only thing the MVA will do is they will suspend or reinstate once they get a notice from the Child Support Agency that says suspend or reinstate. They don't do anything otherwise. So really it's DHS and they are on board.
And that connection will be immediately, or upon, I mean, how will that connection be with DHS and MVA? I just want to make sure that's kind of a...
So the suspension letters all go out first through the Child Support Agency.
Okay.
And then the Child Support Agency, their system notifies the MVA. And the MVA, like I said, they send like a notice if the Child Support Agency notifies them too. It will, I mean, there are still some issues, I think, with the automated system. It might not be perfect, but it's definitely a step. And hopefully the automated system is something that DHS, we can continue to work on with them. But it's a step for sure.
Okay, thank you very much.
Thank
you, Delegate.
Thank you, Chairman. I was wondering if the new Vice Chairman has any questions for the panel?
He's taking detailed notes, actually, over here. Looks like it's better handwriting than the Vice Chair, actually. But having said that.
That was satisfactory.
You have something you'd like to say? You have something you'd like to say?
Yes.
What was that?
Hi, Mom.
With that, that concludes the testimony for Senate Bill 164. Thank you very much.
Thank you.
Thank you all so much.
Delegate Humphrey.
Delegate Humphrey, thank you.
Precious.
Thank you very much. Thank you. You want to take some of that? All right.
Thank you all so much for your time. I know you were here really late last night, so
Thank
thank you
you.
for all you do.
We're a full service operation today. I believe Secretary Lopez apparently is here. We didn't realize this until now. Secretary Lopez is in the back. Come on up for Senate Bill 706 and then Senate Bill 711 after that. Senate Bill 706.
I'm sorry, which number did you want to take first?
706 is fine.
Sounds good.
All right.
Good afternoon, Chairman Clippinger, Vice Chair Moon, and members of the committee. I'm Kevin Geistwhite. I am the Executive Director for the Child Support Administration within the Maryland Department of Human Services. And I thank you for the opportunity to testify today in support of Senate Bill 706. I am joined today by Secretary Rafael Lopez of the Department of Human Services and Ms. Courtney Thomas-Wittenberg, Director of the Allegheny County Department of Social Services and Chair of the Maryland Association of Social Services Directors, or MASD. And I thank them for their presence today in support of this bill. And for Ms. Thomas-Wittenberg's present on behalf of all of our local child support workers who help our families in Maryland every day. The Department's Child Support Administration administers the Maryland State Directory of New Hires, a federally required function for employers to report newly hired employees. While the Department administers the State Directory of New Hires, the statute is codified in the Labor and Employment article under the Department of Labor. This information reported is used by both departments. Senate Bill 706 will expand the authority for the Department of Human Services Child Support Administration to collect additional information using the State Directory of New Hires that does not impact the Department of Labor. As only employers are required to submit newly hired employees, Maryland is currently unable to obtain employment information for independent contractors. Senate Bill 706 will amend family law to add a subsection to define earnings as monies received by an independent contractor as reported on the IRS Form 1099, and also to require the reporting of these independent contractors to the State Director of New Hires. It's important for the Child Support Administration to identify who is working as independent contractors in order to properly locate parents who owe support, to establish support orders based on realistic income and the ability to pay, and to identify how best to attach earnings to support Maryland's children. And for these reasons, I strongly urge a favorable report by the committee.
Good afternoon, Chairman Clippinger and members of the committee. I am Courtney Thomas Winterberg. I'm the Director of the Allegheny County Department of Social Services and the Chair for the Maryland Association of Social Service Directors. The local departments of social services have extensive experience in administering the child support program at the local level in Maryland. Thank you for the opportunity to testify in support of Senate Bill 706. Senate Bill 706 is a significant measure that aims to increase our resources to effectively administer child support programs here in Maryland. Currently, employers are required to report newly hired employees to the State Directory of New Hires. This reporting requirement assists the departments with locating parents, verifying wages, and establishing child support obligations based on the non-custodial parents' wages. Unfortunately, the same recording requirement does not extend to independent contractors or 1099 employees in Maryland. With the growth of the gig economy and the number of businesses hiring independent contractors, this has created a significant challenge for the local departments, resulting in unnecessary delays and barriers in the establishment and collection of child support for the families we serve. We know that wages account for the largest percentage of child support distributions statewide, which underscores the importance of accurately verifying the wages of non-custodial parents. When this cannot be done, children may receive less support than they are entitled to, which can have negative consequences for their well-being and that of their families. Senate Bill 706 addresses this issue by extending the reporting requirement to employers who hire independent contractors. On behalf of the Maryland Department of Social Service Directors, I respectfully ask that you support Senate Bill 706, making Maryland the 19th state and Guam who has already extended these requirements. Thank you.
We're ready to answer any of your questions.
Just guess, first of all, happy Easter to all of you and happy Passover to those who celebrate. My question is, I think this is a great system and it should work beautifully for people with Social Security numbers, so congratulations to all of you. And I certainly support the spirit of the bill. My question is, what happens if the non-custodial parent has an ITN number rather than a Social Security number, because it's often, ITN numbers are associated often in the press and things like that with people who are undocumented, but in fact numerous people who are here legally have ITNs. So I'm just wondering how it's going to work for people without Social Security numbers.
Thank you for your question. We can use both SSNs and ITINs right now in our program. So it would not change anything. We would continue to use either number that is used in applications and so forth.
I appreciate it.
Thank you all for presenting today. Can you give me an idea with this loophole, what is the estimated dollar amount that goes unreported?
Actually, because we don't have the information, we're not really able to answer that question. Without having this information, then we'll be able to know what we're missing.
Thank you.
Thank you so much, Mr. Chair. Thank you. I have a couple questions. So if the non-custodial parent also has a full-time job and a side gig, to use your words, then you would look to try to obtain both of those wages?
Yes, that's correct. We would use the first full-time, first, and if it fulfills the obligation, we would not need the second. But if the first full-time does not fulfill their obligation as ordered by the court, then we might need the second income to continue to get the support for the children.
So let me just say I'm very challenged with this. And, quite honestly, I hope we don't move this bill. because I believe that this impact, I'm unapologetic about being a Black person, and I believe that this bill would impact not only Black, but rural individuals, people who have a lot of side gigs, may be unemployed and employed again. And sometimes people take side jobs because they're trying to get additional monies because they already have child support taken out at the normal rate. And so I guess I'm just trying to understand, why is something like this a necessity? We heard the previous panel where we know that driver's licenses are being taken. And I recognize we may want to be on par with some of our other states, but I really believe this can have an unintended consequence on, I just have this whole thing in my head that, the system has torn Black fathers and Black families all the way from slavery. And so so it's just my own personal, I love history. So I feel like child support continues to do that. I'm not saying people do have responsibility and an obligation, but when we keep taking and taking and taking, especially gig work, I do find that to be challenging. So why do you feel a need to feel like you have to have another way to take additional employment that folks are trying to get?
You want to answer, then I'd like to answer.
Okay,
as well.
certainly.
Go ahead.
Thank you for your question. And one thing I wanted to say first of all is that, one of our goals is that we want to help the whole family as child support. The program has evolved over the years from what many think and know the child support program to be, and that today we do help the whole family. So we are interested in helping non-custodial parents as well, as indicated by the prior conversation where I'll support the amendments to the driver's license bill. With this one, what we really want this information for is we want to help the NCP by making sure we are establishing orders based on their ability to pay and realistic income and understanding what they are making, because we also want to make sure they're benefiting the child. What we want to do in child support is make sure that the child is receiving kind of the fair equity of the income that's being made into the family as though they were still part of an intact family. So a child is part of an intact family is benefiting from all the income, whether it's full-time or also part-time. We want to ensure we understand that and we can make the right decisions to help the whole family, from the child, which is the best interest of the child, to also the NCP and the CP. And I hope that helped answer your question, but I'll let Secretary also comment.
Sure. Thank you, Delegate, for your question. I wanted to give you a couple of responses based on what you've said. I think it's important also to take a moment to give to respect and honor history and how it's been abused. And so let me be really clear about that. It's not simply your personal opinion. I concur with you. There is decades and hundreds of years of fact about the way in which our governments have torn apart families, particularly families of color and particularly Black families. So I wanted to say that for the record.
Thank you for saying that.
No, absolutely. It's fact. Number two, I recently had the opportunity to speak before the state of Maryland courts. And so we had magistrates and judges and commissioners. And one of the things that I grounded my remarks in was my own experience when my mother divorced my own father and we never received a penny of child support. And when you look at the way in which child support systems have been structured in this country, what we are really talking about is arguing over poor people and the struggle to survive and the high cost of poverty in this country. Now, that said, the way in which we'd like to move the department forward in this administration is to look at the whole family, the whole way in which we can support child well-being. And so we believe that there is a need to support children overall. And so whether you are in the gig economy or have a part-time job, there is a responsibility to care for children. And so we have to be thoughtful about the way we do that. We have to be creative in the way in which we use the tools to not tear apart families. You'll notice the last panel that spoke negotiated with various members of the Child Support Administration to find a path forward in which everyone can agree. And what I've learned in legislation is that that means not everybody's happy with the outcome, which is what you saw this afternoon in terms of the exchange that was being made. Not everyone got what they wanted. Number four, the way in which this country works, in order for Delegate Phillips to have his question answered, the second part to that answer was that if we actually move the number beyond what Delegate Taylor wanted, we would be out of federal compliance with the way in which the federal government is written. So I would argue, I'm personally not happy with the way the federal government law is written on this. I think that there is extraordinary room for improvement about the way in which we support families, the way in which we use child support enforcement as a tool to support, not to tear apart. And so I think that there's lots of things that this department can and should do moving forward that we perhaps haven't done in the past. So I just wanted to make sure I responded directly to your issue. I concur with much of what you said, and believe that this is one of very many tools that we'll have to learn from. I don't take it as wanting to be part of the 19 that Courtney mentioned, as much as to say that we have to be creative with the way in which we support kids. And as a father myself, I have a responsibility to support my kids, regardless if I'm making 10 cents or 10,000. And I would actually encourage every parent to take that responsibility for their children, regardless of where or how they work.
Absolutely, thank you. I'll be interested in talking to you, and maybe
Sure.
Listen. You know, I grew up in a two-parent household. I was his daddy's girl, so I
You
don't
understand.
have those.
Yeah, you don't have those
I don't
challenges.
have those
Yes,
issues.
that's right.
But I do believe that there is some historical issues, and I'll be
Absolutely.
happy. I would love to talk with you. I understand
Happy
you need
to.
to take care of children. Often children, you know, that's a whole nother issue, but it may be a different way in which we can go
Absolutely.
about ensuring
Absolutely.
that the children are made whole, not at the expense of the fathers who are really trying
Absolutely.
to work and make
Absolutely.
ends meet to take care of their families.
You're correct.
So thank you, Mr. Chair.
Certainly.
Thank you, Mr. Chair, and thank you, Mr. Secretary,
Certainly.
for being here and everyone. I have a couple of questions. I don't quite understand the bill, so I've been reading the fiscal and policy note and got even more confused. Because
That happens, I think.
Yeah, because one, they say independent contractor employer. That confuses me, because if you're an independent contractor, you don't usually have an employer-employee relationship. That notwithstanding, I would think that people who need to be involved in this, and I think I might have gone too far, but the Department of Labor, the Department of Human Services, and the Office of the Comptrollers, and also I have the IRS. But is there a synergy between all of those groups that I'm not understanding? Because in the fiscal and policy note, it says that the bill applies similar provisions of, and they give the labor and employment article, to an independent contractor's employer and CSA, and that just is confusing to me. So can you just explain to me how the Department of Labor or the Office of or the Office of Comptroller plays into this, if at all?
Sure.
Yep. So what happens here in Maryland is that the law for the state director of new hires is in the labor article, but the Child Support Administration and Department of Human Services actually manage and run the State Department of New Hires. The labor uses information from the employers for their needs, which I'm not quite clear exactly all the things they use it for, but then we need to use it for the things we need to do, which is federally required, and as I stated, in terms of help determine the income for the family and when we're setting the orders out there for that. In terms of independent contractors, we're looking for those where they are working for larger companies that are having the 1099 forms, and that's why we refer to the employee unit in the document here, but independent contractor being redefined separately as those that make the 1099 form. So I hope that helps clarify.
That does help. Okay, so let me just make sure I understand. So would the employer know that there is a child support order so that they would know? I'm sorry, it would be the independent contractor who would have to report that 1099 to you all. Is that the way it would work?
What we would do is we would use our existing mechanisms. So we have a group that runs the program for us. They reach out to employers today to notify them of this requirement and how to report their new hires. In this case, we'd be reaching out to extend that to reach out to independent contractors who employ large groups of individuals to report to us that information so that we will then know that they are an independent contractor, they are making this money, that then we can find ways to use that to establish the orders as well as to figure out ways that we may be able to garnish that in new ways because it doesn't currently exist today in Maryland.
Yeah, I mean, it's really kind of blowing my mind a little bit because I use a lot of independent contractors. So let's just say, and I get them from a service called, I think it's called Upwork. I don't know if you've heard of that company. But Upwork has various skill levels. And, you know, there used to be the Fiverr. I don't know if those folks have to do 1099s or not. But my point is that are you saying that that's who you would be reaching out to? Because those individuals are actually independent contractors that, you know, that I go to and I say, I need this particular project done, and they take care of it. And then later, if I need to, I will do a 1099 for them. Is that the situation? And so that independent contract, I mean, that Upwork, the larger company, would need to notify you all? Is that?
Yes. Yeah,
Okay.
it would be Upwork who would notify us, not you who are selecting the independent contractor from them for your needs.
And the service which we pay for is the one reaching out to that individual, not you.
Right. Okay. Now I understand it. Okay. So we're kind of going with the mobile delivery drivers too, a little bit. would they also be included here? Like a DoorDash or,
They could be.
yeah, okay, all right, thank you.
Thank you.
Thank you, Mr. Chair. Delegate Bartlett sort of hit on one of my questions that I had with regards to the independent contractor, because as an attorney, I'm thinking, oh my God, same thing, we hire, independent contractors, like say, my process server, for example, I know his name's Matthew, but he is not an employee of my firm. He is an independent contractor with my firm. And so I'm sitting here reading this like, I don't know his social security number. And so now would I become obligated to now have to report his social security number and get all of that information? So anyway, so I think you kind of sort of
The
explained
quick
that.
answer to you is no. You would not be the one.
Okay. The other question I had, you mentioned that I was wondering if you knew what the other states were that kind of implement this procedure. And for the states that do not implement this procedure, what procedure do they have in place to comply with the federal regulations that you mentioned earlier?
Sure. I don't have the number of states, actually, maybe Courtney has them.
It's 19 plus Guam.
Well, no, you mentioned that in your testimony. I was just wondering who the other 19 states were.
So I don't have the full list with me at this hearing. I actually had it at the Senate hearing. We can provide that. I don't want to misquote, but I do believe the closest state that has this compliance is West Virginia.
Okay.
I think Virginia may also have it. And the other part of your question about other states, they're all looking for this as well, because this is a challenge for the child support programs nationwide. And also the federal government is looking at ways. This may actually become eventually a federal requirement for all states to do. Right now, states are trying to do it on their own, just because we haven't been able to get federal regulation changes.
Okay. All right. Thank you.
Thank you, Mr. Chair. I own a business and am very familiar with a child support letter, and we've had to comply. Our 1099 employees don't make the same amount every year. They're not under contract. They may make, one amount one year. They may make another year. Does your system have the ability to track from year to year what an income is, or are you only going on that particular year? You base child support payments on that year, and then you're going to have to go back for 1099s to make sure that that base amount is still the same, because it may change from year to year.
Yeah, we currently, when we really establish an order, we use the income at the time. But when there are changing circumstances, such as that type of thing, we can modify the orders based on that information. And our system doesn't currently track income, but with the other bill that we talked about prior to this, we are going to be working to make some changes to the system to track income more, so we can actually monitor that very thing that you're talking about.
And when does this go into effect?
We don't have a time frame yet
When
for
would
it.
Okay. Thank you.
The bill itself, or the changes to the system?
Both. The bill itself,
The bill is
assuming it's
October this
sometime
year to start getting
October,
information.
yeah. But, okay. All right. Thank you.
Any delegate tolls? Again? Delegate tolls?
Yes, I know Charlotte.
Oh, I'm sorry, Delegate Crutchfield then, because.
It's okay. Thank you, Mr. Chair. As I was sitting here listening to my colleagues ask questions, I was thinking that there might still be a little bit of a loophole here with independent contractors, because there are independent contractors who are not actually using an employer, okay? They actually are truly independent contractors with an entity. And so, to me, it sounds like you would be asking also the entity, right, that they have a contract with to provide this information, because the entity usually, in order to pay them, will ask for a W-9, and then from there, they would create the 1099. So I guess I'm just asking, what would you do with those situations?
Good question, and I agree with that. I don't know if this bill will cover everything. We are looking for the larger employers with this bill that we know we'll be able to reach out to. Some of the smaller ones may still be another thing to consider going forward as we consider learning more about the information from independent contractors that we can obtain.
Okay, because there are large entities, and this is what they do, just direct contracts. So anyway, okay, thank you.
Thank you.
Thank you, Mr. Chair, to be short. And I was thinking this when I was kind of asking my first question. So Delegate Taylor opened up the door. And so every, let's just say this bill goes through and your system, as you indicated, is not set up to do, you know, certain functions. With this gig work, the amount could change monthly, it could change annually, is that correct?
Yes, I think it could be, and we get that information and we make decisions using that information. So orders would be set based on the knowledge of the income, again, the ability to pay, so it would look at the history and the track record of how they're being paid as well.
And so somebody would have to open that up, because when they set the child support payments, right, they would have to set between the parent through the courts or however whatever system they use. And let's just say you did have this in place and you use the gig work. If they were no longer doing that gig work, say after the order has been set up, you know, 2 months later, then they still would be required to pay whatever amount that how would you track that if your system is not able? Because let's just say they have to pay $500 additional, you know.
I want to answer this. Okay. So this is about agency. So I've been a 1099 employee myself. And if I was required by the court to provide child support for my children, I'd have to follow that order. If my job went away, my gig economy, when my gig job went away, why would I not say I no longer can afford that? Why would I not go to the court or to my custodial partner and say, I can't do that? So it's self-agency. That's number one. Number two, we would want to make sure that any changes in anyone's income, be it gig economy, full-time job, or other work, whether it's the entity that Delegate Crutchfield talked about, that all of these are options in which to support the child. That is what we're trying to focus on. So in the spirit of not having perfect be the enemy of the good, this bill is imperfect if you pass it. We will then test out what is the information that we will need to use to strengthen the collection of the information, the modification of the orders, the partnership with the courts, and most importantly, the partnership with the non-custodial parents, who then have to work with child support administration staff to clarify, clean up, and amend the dollar amount that they would then spend monthly, depending on what they earned.
Okay, thank you so much. I don't think it's ready for prime time, because sometimes you have contentious parents, and then also they need to pay for attorney fees to go back and change. So I would, you know, have to respectfully, you know, disagree that your system is not set up and ready for this. So thank you, Mr. Chair.
So really quickly, I heard you testify that this should only apply to large employers. But I didn't see large specifically in the bill, so would you be open to a friendly amendment just to make sure that that is specified in the bill, since that's what I thought I heard you testify to?
I think we'd be open to something like that, because that's probably the intention of what we're going to get most likely out of this initial bill.
Okay, thank you.
Seeing no further questions, that concludes the testimony on this bill, but now they have another bill. Senate Bill 711. There are two more to go, everybody. Senate Bill 711, I think, is yours as well.
It is?
It is.
All right.
Good afternoon again. For the record, I'm Kevin Geiswhite, the Executive Director of the Child Support Administration within the Maryland Department of Human Services. I thank you for the opportunity to testify today in support of Senate Bill 711. Again, I'm joined by the Secretary of the Department of Human Services, Rafael Lopez, and Ms. Courtney Thomas Winterberg, Director of the Allegheny Department of Social Services and Chair of the Maryland Association of Social Services Directors, or MASD. Senate Bill 711 will extend the department's existing enforcement tools that already includes casino and lottery intercept to now add sports wagering and fantasy competition. When a parent owes child support but is not paid, past due arrearages accrue. Child support has a variety of important tools to assist us in ensuring collections are received to support Maryland's children. Since 1988, Maryland has intercepted lottery winnings for this purpose. And since 2015, when casino winnings were added, Maryland has collected approximately $5.6 million to support our children. Senate Bill 711 adds sports wagering and fantasy competition to our ability to collect winnings to support children who deserve financial support from both parents to grow and thrive. The Department also agrees to a friendly amendment that's been proposed by the Maryland Lottery and Gaming Control Agency to extend the effective date from October 1st, 2023 to June 1st, 2024 to allow additional time to work out details with the licensees. All the processes that are currently in place and working well for casino and lottery winnings will now also be extended to include sports winnings and fantasy competition winnings. When an obligor owes $150 or more in past due support, the sports wagering licensee or fantasy competition operation would withhold the prize and send it to the Child Support Administration to satisfy payment toward arrearages that are owed to the obligor's child or children. Maryland's children deserve all their financial support that we are able to collect on their behalf, and for these reasons, I strongly recommend a favorable report by the committee.
Good afternoon. For the record, I am Courtney Thomas Winterberg, Director of the Allegheny County Department of Social Services and Chair of the Maryland Association of Social Service Directors. Thank you for the opportunity to testify in support of Senate Bill 711. Child support helps to ensure that children have access to necessities such as food, clothing, and shelter. It's also a critical component of reducing child poverty and improving child well-being here in Maryland and nationwide. Since 1988, children in Maryland have benefited from lottery intercept enforcement that has allowed the state to collect from non-custodial parents with arrears balances that exceed $150. In fiscal year 2022 alone, lottery intercept enforcement accounted for over $750,000 that was collected and subsequently distributed to families. Senate Bill 711 would amend current law by expanding it to include the interception of winnings from sports wagering and fantasy competition, which was legalized in the state in 2021. The interception of winnings from these competitions would serve as an additional tool for child support enforcement, as these activities can generate substantial winnings for participants, which could then be used to help non-custodial parents meet their back child support obligations. On behalf of the Maryland Association of Social Service Directors, I respectfully request your support to pass Senate Bill 711, so Maryland does everything possible to ensure that non-custodial parents meet their child support obligations and that children receive the financial support they both need and deserve.
Ready to answer your questions.
Mr. Chairman, thank you, panel, for coming in to testify. I've received a lot of support from my support community in here, and so therefore I want to know, at what dollar amount would you start collecting money? Let's say if a person made a wager on their computer fantasy bet and they won $40, would you be taking a portion of the $40, or would we take the whole $40? How would that work?
It's only over $150 that they would have to report. They'd have to withhold the money from the winnings.
So if a person wagered $200 on their computer at home and they won, let's say $400 or something, then you would be able to intercept that?
Correct. Up to the amount of the arrearages that are on their obligation.
Okay. Thank you very much.
Delegate Crutchfield and Phillips.
Thank you, Mr. Chair. I think my question was answered through Delegate Conaway's question, but I do have just, you might know this. Is there a certain amount that the IRS actually considers wages when you win lottery or any other, betting? Is it like $2,500, or is there a certain, you may not know this, but I'm just curious.
I don't know that, but I can try to look that up for you.
It's okay. It's okay. No, I was just wondering kind of. All right. Thank you.
Delegate Phillips and Boucher.
So Delegate Crutchfield kind of went down that path that I was going, because at some point, certain winnings require you to pay taxes. And if, in fact, and sometimes those taxes are reported at the end of a tax year, if, in fact, you took all of the winnings, that individual would actually then be getting hit twice, because I still got to pay my taxes, but I have nothing to pay the taxes with. Is that a fair statement? And I don't know how it works today, because you're doing something that you're already doing today, but it seems to me that that's, where's the adjustment?
I haven't heard of any issues per se with that, with our child support. I know that child support takes precedence usually over tax issues in other areas. It may be this one as well, but I haven't talked with the IRS specifically about this issue.
Okay. And I have a bill this year that actually tries to address issue of child support and workers' comp. So when an individual receives a workers' comp award, in various jurisdictions, people handle it differently. Some child support enforcement officers want the entire award. Some, say, look, we're limited to 25%. I think it's passed now, so maybe that'll get resolved. But this idea of potentially not taking all of the money, so that an individual, if they do receive an award, this is different because it is betting. It's different than workers' comp. But it seems to me that there may be an opportunity for that individual to receive some of the money. Under normal circumstances, you would only be able to garnish 25%. So how do we do this different?
Good question. Obviously, each remedy has a different thresholds, different rules around them from the federal government as well as state requirements. So I don't know exactly with the 25%. It does a different, slightly different issue in that sense. But that is how we've been doing it with casinos and up to now in lottery winnings.
Can I answer from a different perspective? So I'd like to sort of take this a few notches back, which is when I think about the testimony that was just presented, it was around arrearages. That's actually the issue that we're talking about. Right. So let's play this out for 1 second. So I'm a father, and I owe these two children child support. I've not paid these children child support for the last 5, 6, 7 months. But I go and I bet something, and I win $1,000. The way in which this bill is currently written is that we can intercept a portion of that money to make sure these children get child support. It's that basic. The choice.
You said a portion, but I thought you could get all of that money.
Well, it depends on what the father owes. So if the court says, I owe these children $100 a month, and I want $1,000, right? And I'm only, let's play that out. I'm behind 4 months. $400 of my $1,000 earnings will be intercepted. That's what we're talking about here. So DHS, as your state agency responsible for administering child support, we don't get that money. The state general fund money is not for the state of Maryland. It's for these two children. And so the choice you get to make as legislators is what is the policy you want to see in this state if, A, you want to draw down federal money to augment what you spend here in this state around child support enforcement, if at all. And I'm saying, for me, as your new secretary, it's that basic. You could choose to not draw down any federal money. That's a choice that this state gets to make. We also imagine that if you didn't want to pass this bill, you shouldn't. And I can say that as your secretary. You're probably giving this man a heart attack right now. But for me, it's that black and white. It is your job to vet these bills and to feel comfortable with whether or not you want that to be policy and then forward it to the governor for signature. That is your right and your duty. And if you don't want to pass this right now, don't.
No. Because at the end of the day,
that's what I see.
At the end of the day, I don't want to sacrifice the federal money.
No, right. There you go, my friend. There you go. You don't want to understood.
No.
Understood.
I don't want to sacrifice the federal money. But think about how you just described this.
Right.
And so I'll give you a different scenario.
All right.
I've got a dad who's been out of work for a year. So he now has arrearages.
Understood.
Right?
Understood.
He happens to get lucky. He goes to the casino and he happens to get lucky. And he wins $1,000. This is a person that's been out of work for a year. He wins $1,000. He needs to take care of his kids. Some of that money ought to go to his kids. The question is, should all of it go to his kids?
And what I've said with...
And right now, that's what we do.
Right.
And could we do that and still be in... Could we make a different decision and still be in compliance is, I guess, my question.
Right. And so to that specific scenario, I'm going to say just based on the policy, that is a policy decision of this body. So what we're coming to you with is we are giving you a set of options. We're saying based on the federal way in which the law is written, the way in which we can legally draw down money from the federal government to run our operation, the way in which right now COMAR and other pieces of law are written in Maryland, this is an option for you to consider. If that exact scenario, sir, played out, and I, the father, was out of work for a year, and I've not reached out to CSA to amend my orders or to my potential custodial parent, a partner, with or without the court, if I want $1,000, you are right. We would, on your behalf, intercept those lottery winnings to support the children that I have. That is what would happen. And that's why I say, with all due respect, it is a policy choice of this body to make. And that's why, for me, it's not being flippant. If you don't like that choice, don't vote for the bill. If you want an alternative, propose an alternative with us, well, at this point, it's next year, because we have a few days until signing die. So that is a choice you get to make.
Thank you, Mr. Secretary.
Certainly.
All right, Delegate Boucher, then Delegate Simmons.
Thank you, Chairman. And I appreciate how noble this effort is. And having read through the bill, I'm a little bit unclear on the interception mechanism. Is there a registry of Social Security numbers of people? What triggers the wage company to garnish? Does it need to be initiated by the other parent? How does that process work? What kicks it into place?
Yeah, what we do right now is we actually share file information with the lottery and the casinos.
So they get a registry?
They get a registry of the information.
Okay.
So they'll have the information, and they match individuals against the list. If they match, then they have to withhold the money to return to us. We would do something similar here in this situation. We're also looking at a possible web lookup, especially since we know that some of the sports are smaller, and we don't want to send all the information to them because they don't have the same infrastructure that the larger casinos have. So we may be able to do that for them. They would look it up instead through a web lookup to match their winnings before they would give out the money to the individual.
Well, that's good. That means the other parent doesn't have to take the initiative to do it. That's all. Thank you very much.
Thank you, Mr. Secretary, and the rest of the panel. As you can see, there are some crap players here on the panel, but I've had the opportunity of working at a casino and have seen where individuals have won large amounts of money and gotten to the window. Some will take it in cash, some will take it in checks. I do know that we use an ID system when it comes to giving out money in winnings, and those folks do go into a system because some people on their way out of the casino say they got robbed, you know, and certain things, they may bounce from one casino to the next, like they'll leave here, go to Delaware, then go to New Jersey. So is there a mechanism to track individuals from the state of Maryland out of state?
I'm not aware of that right now. Thank you.
All right, Delegate Tomlinson with the last question.
Thank you. It's good to see you again. Kind of the opposite of what Delegate Phillips was saying about, you know, the guy who gets lucky one night with $1,000. What about people? And I'm thinking back to a person I do know who I think since 18 he's never had a real job. He's just played online poker and poker in real life. And maybe the question is, maybe how he does his taxes. But for somebody who's, I mean, completely, and especially now with sports betting, you know, legal, I'm sure there's going to be more of this. People who, and I wouldn't recommend it, but people whose entire life, I mean, that is their sole source of money. How does that, how does that play into this?
It's a good question, Delegate Tomlinson, and I would say that this bill is not going to be a net for everyone. There are lots of people in all of our lives who have all kinds of interesting job arrangements, let's say. Don't know how they pay their bills or pay their rent or their food, but they do.
You're looking at a room
and
of
we
them,
all
but
know
yeah,
that.
Keep going.
That's right. You have a part-time job, quote unquote, right? That said, we would be remiss if the three of us, or on behalf of DHS, said this is going to catch everything and everybody. It's just not. And so I think the question is, back to Delegate Phillips' question is, what is the policy this legislature wants to set forth on behalf of the way in which we support children who happen to be clear, at no fault of their own, in situations where a parent, or a potentially non-custodial parent, is able to help them with their well-being? That's the larger policy question here. And this is one of many tools in that larger federal and statewide enforcement toolbox.
Gotcha. I like the bill. It was a scenario.
Understand.
It was a
It's a
scenario that was
legitimate
playing
question.
through my
Understood.
head. I got to check on this guy now, see how he's doing. See if he's still surviving.
Yeah.
I saw him on Facebook. He looks like he's doing good.
And as we know, a lot of people don't pay taxes, so it's just a choice.
Yeah.
We just need to know, are you going to be able to intercept people's bets because they're going to be using credit cards or something like that to log into the system or to get their chips or whatever they're doing?
It would just be the winnings that we would be intercepting.
The winnings, how are you going to get the winning?
From the licensee.
So if a person goes into the casino and wants to play, I don't know. They have to use their credit card or they have to cash in a chip or something?
Well, I have to know, I don't know I don't know how it actually works in the, I've
You don't know how this works.
I don't know how gambling works in the casinos, but I know how it works when they win. The casino in this case would have to, it currently matches the information and finds that there is an obligor that owes the money. They have to withhold that and give us up to the arrearages.
So if a person wins and they take a chip and say, okay, I won $500, now they're going to look and say, well, if it's over 150, we need your information to change this into cash.
They'll already have information.
How are they going to have the information?
So we're sharing the information with the casinos and the licensee.
If I walk in and pay $500 for the chip, cash money, how are they going to get information from me?
Well, the NCP, and in that case, the person will have to identify who they are with identification, so they'll know who they are to give their winnings out.
Okay. Thank you very much, Mr. Chairman.
Okay, thank you very much. That concludes the testimony on Senate Bill 711. Now for the very last bill of the legislative session for us. This is the last bill. Okay. Senate Bill 710. Wait, is this you guys?
Oh, no, I was saying Denise.
It's a different crew of characters.
It's slightly different crew.
Slightly different
Slightly
crew.
different crew. That's right.
Still characters. All right, Senate Bill 710. Go ahead.
Good afternoon. Chairman Clippinger, Vice Chair Moon, and honorable committee members. I am Denise Conway, the Executive Director of the Social Services Administration at the Maryland Department of Human Services. I am joined by Rafael Lopez, our Secretary, and Ms. Courtney Thomas Winterberg, who is the Director of the Allegheny County Department of Social Services, as well as the Chair of the Maryland Association of Social Services Directors. April marks National Child Abuse Prevention Month, and I am delighted to be able to have the opportunity to testify today in support of Senate Bill 710. This bill was last introduced to you during the last session, and unfortunately during those last couple of days in session it didn't make it through. So we're hoping for a favorable report this year. Maryland's children should be safe from maltreatment no matter where they are. In order for Child Protective Services to share information about certain CPS investigations with public and private schools, the Human Services article would need to expand to permit the sharing of neglect investigations with schools. Under the current law, sharing of child abuse is already permitted. In addition, the statute would need to allow for improved information sharing with child placement agencies regarding any CPS response. At present, Human Services Article Section 1-202 authorizes the disclosure of reports of suspected child abuse to be shared with public and non-public schools in situations involving school staff or independent contractors of the school system. The school superintendent or the principal can carry these out at appropriate personnel or administrative actions following a report of suspected child abuse that is committed by a school employee or independent contractor. For example, this would include a bus driver or a bus assistant in that school system. Currently, the sharing of child neglect reports is not authorized. I want to make that distinction very clear to this committee. As written, the current law leaves a wide gap in our safety net to protect children from harm. We are almost there, and with a favorable report, together we can close the gap that now exists around child neglect. The department asserts, and I hope members of the committee will agree, child neglect allegations are equally important for school administrators to be notified about so that they make appropriate and timely personnel action to ensure the safety of Maryland's children. As provided in our written testimony, child neglect represents more than half of the reports received by the department. 9,536 of the 18,060 reports received in calendar year 22 were related to neglect. I thank you for your time, and I urge a favorable report.
Good afternoon. For the record, I'm Courtney Thomas Winterberg. I'm still the Director of the Allegheny County Department of Social Services and the Chair of the Maryland Association of Social Service Directors. Thank you for the opportunity to provide testimony in support of Senate Bill 710. The local departments of social services, through our Child Protective Services units, are responsible for the assessment, investigation, and intervention regarding cases of suspected child abuse and neglect. The department currently has the authority to disclose reports of suspected child abuse by an employee or independent contractor to authorized personnel of public and non-public school systems and child care facilities. Sharing these reports serves as an important tool to prevent further abuse, as it allows appropriate personnel action to be taken if warranted. Senate Bill 710 expands upon the department's authority to include disclosure of reports of neglect, regardless of whether the victim, which is a child, attends the specific school system or child care facility. The passage of this legislation would also allow Child Protective Services to disclose a report of abuse and neglect to a child placement agency when the alleged maltreater is someone other than the foster parent, but resides within a licensed foster care household, is a licensed member, or is a family member or someone in the home that is responsible for providing care and/or supervision to children. We believe this expanded authority is not only important, but necessary, given that neglect is the most commonly reported type of maltreatment statewide, and since 2016, it has represented more than 60% of the cases annually. We believe the expanded disclosure authority will enhance the safety of all children in Maryland by helping to inform and mitigate the risk of harm. I respectfully ask for your support of Senate Bill 710.
Good afternoon, Chairman Clippinger and Vice Chair Moon, members of the committee. I'm Mark Millspaugh. I'm the Deputy Director for Social Services with Baltimore County Department of Health and Human Services. I also chair our county's Child Protection Panel. I thank you for the opportunity to support Senate Bill 710. Also, I want to say Happy Child Abuse Prevention Month. As a child abuse prevention professional, I'm going to touch on the second part of this bill that we haven't yet touched on. Another gap that this bill will close. It will allow us to report to child placement agencies. So we use a lot of treatment foster care agencies to place kids into treatment foster care homes. We currently can report to those agencies if an employee of that entity has an indicated finding of abuse or neglect. What this bill will allow us to do is to expand that so that other people who frequent that home, a babysitter, a family member who comes into that home, who's not an employee of that entity, if they have an indicated finding, we can close the gap to protect children by making that entity aware of that environment and then potentially suspending placements until we can further the investigation to determine if children are safe. So this closes two gaps in the child protection system, one related to our relationship with schools, who we work with very closely, and then the second one related to child placement agencies and other private providers, so that we can report other potential risks to children.
Questions now for Delegate Simmons?
Thank the panel once again. Just a question. When you look at the total number of complaints that y'all receive on let's say, a yearly basis, how many of those do y'all find as valid?
I would say that a fair number of those cases are what we call in Maryland ruled out, and probably less than half are indicated or unsubstantiated, but I can get you those exact figures for calendar year 22 if you would like.
Please, yes, absolutely.
Sure.
Thank you.
Any other questions? All right. Delegate Simmons asked the last question then, and that concludes the testimony. Senate Bill 710. Thank you all very much.
I hope we didn't scare you too much.
Oh, not at all. Not at all. Not at all.
Right.
Exactly.
Members of the committee should be
Delegate
aware.
Toles and I see eye to eye.
Thank you. Members of the committee should be aware we will vote tomorrow at 9 a.m. Amendments to Senate Bill 1, please provide them as soon as you get them to the committee offices, and we'll be in further touch over the next several hours if there are any changes. That is a moving target at the moment, so just stick with us, all right? Thank you all very much.